We have Bill Cannon, FTIA. Bill joined Blake Dawson in 1974 and has been a partner of the firm since 1980. He is the team leader of the Blake Dawson's tax team and has extensive experience in advising on GST and stamp duty. He also advises on income tax issues concerning trusts, partnerships and Part 4A. Bill is an assistant editor of Hills Duties Legislation, LBC Information Services, and Bill graduated from the University of Sydney with an LLB in 1973 and an LLM in 1976. We have Ray Conwell, FTI-Life. Ray is a chartered accountant and practicing lawyer with Deloitte Lawyers Proprietary Limited. Prior to joining Deloitte more than 22 years ago as a partner, Ray was with the Australian Taxation Office for 24 years, both in Canberra and Melbourne, and was an architect of the General Anti-Avoidance Rule in Part 4A of the Income Tax Assessment Act 1936, on which Division 165 of the GST law is based. Ray has recently successfully acted for clients in federal court litigation on Division 165. Ray is a former national president of the Tax Institute and is also a member of the Australian Taxation Office's GAAR panel, and that advises the Commissioner on the application of the GAAR. Robert Olding, FTIA. Robert is the Australian Taxation Office's Deputy Chief Tax Counsel, responsible for technical leadership in relation to GST and other indirect taxes, and has been closely involved in most of the leading GST cases. Before joining the Australian Taxation Office in 2002, Robert was an indirect tax partner at KPMG. And finally, but by no means least, Mark Tafft. Mark is a partner and leader of the Australian indirect tax practice at Ernst & Young, with over 24 years' experience in indirect tax consulting. Mark was admitted as a partner of Ernst & Young in 1995 and served as a partner with Anderson from 1999 before rejoining Ernst & Young in 2002. Mark has extensive experience in servicing large multinational and domestic clients, property clients, infrastructure projects, financial institutions, government and semi-government authorities and industry associations. Mark holds a Bachelor of Commerce, Bachelor of Laws, Master of Laws with first-class honours and is admitted as a solicitor. Can you just please make them all feel welcome?
Thank you, John. Good afternoon again, everyone. We are going to endeavour to do a few things this afternoon in relation to Division 165. But just for myself first, if I could say what I'm not going to do, so that I can deny it in advance, is say that any arrangement is acceptable or not acceptable to the Commissioner. So if that's going out on the Twitters anywhere, I deny it already. For the very good reason that these matters are entirely sensitive to their individual facts, if I can quote the Commissioner in a couple of decision impact statements recently. And the other thing is, notwithstanding impressions you might have been left with over the period of the conference, I'm not going to announce an evil scheme to apply Division 165 in respect of 105-65 refunds either. What we are going to seek to do is really in 3 or 4 stages. First of all, have a look at the general outline of Division 165 and highlight some of the differences between that provision, that division, and Part 4A of the Income Tax Assessment Act. And I'll lead the group through that discussion, or at least kick it off. Then Bill will talk about some of the evidentiary issues that have come into focus very much in the Part 4A cases in recent times. And then we'll try to draw out some of those points by having a look at a case study drawing on the Luxottica matter, which Ray will lead, and other case studies relating to M&A transactions. So that's the plan. Thanks. So as you'll be very much aware, Division 165 and Part 4A share the same broad architecture, the same broad structure, but there are some significant differences, quite a number, and we are going to just focus on 4 of those in particular. One is the objects clause or provision in Division 165-1, Second is the alternative test in Division 165, that is the principal effect test. Third, have a look at how GST benefit is defined in comparison to tax benefit for Part 4A purposes. And then fourthly, have a look at the broader range of factors that are available for consideration or required to be considered in determining the dominant purpose test or principal effect test, with a particular focus on the suggestion that Division 165 might permit, contrary to the jurisprudence on Part 4A, permit reference to subjective